minutes.
Thank you, Chairman Rush and Ranking Member Upton, for holding this hearing today. And thank you, Secretary Brouillette, for testifying today as well. As you know, the RFS is a key economic driver in my home state of Iowa, and actually throughout farm country. And the biofuels industry has been hit hard by the COVID-19 pandemic. Of course, the pandemic only exacerbated the pain that this industry had already been experiencing, in no small measure due to the explosion of small refinery exemptions granted by this administration, which have wiped out over 4 billion gallons of biofuel from the marketplace since 2016. In January, as you know, the 10th Circuit Court of Appeals found that in order for a small refinery to be eligible for an exemption, the law requires that that refinery have an exemption in place to extend, meaning that they must have received an exemption each year in order to be eligible for a future exemption. Unfortunately, rather than adhere to the ruling of the court, many small refineries have submitted retroactive waiver petitions dating as far back as 2011 in an attempt to fill in the gaps in years where they did not receive a waiver. According to EPA's own data, by the ruling of the 10th Circuit, there should be no more than 7 small refineries eligible for future exemptions. And yet EPA recently confirmed that it has received 52 so-called gap year small refinery petitions, which if granted would equate to a loss of an additional $2 billion of biofuel demand. So, Mr. Secretary, I have a series of questions here. I'm going to try to get through all of them. And if I cut you off, I apologize, but I want to get through as many, if not all of these, as I possibly can. The first question is, have those gap year petitions been scored by DOE and sent back to EPA? And if not, when will that happen?
Thank you, Mr. Loebsack. I appreciate the opportunity, and thanks for your conversation as well earlier this week by telephone. You know, I will get back to you on the 50-plus applications that may have come from EPA. I'm not quite sure where we are in the process. I'll just state that, there are differing legal opinions about this 10th Circuit case. I think some are reading it as an opportunity to file these gap applications, if you will. I'll also just, state for the record that if EPA sends us the application, we're required still to evaluate it. So I'm assuming that we're doing that today, and I'll get you a precise answer as to where we stand in that particular process.
I'm going to ask you for your opinion. Do you believe that the law does allow EPA to grant these gap year petitions?
I'm sorry, say again, sir?
Do you believe that the law allows EPA to grant these gap year petitions?
Well, that's a good question. I'm not quite certain about that. I'd have to review the case very closely, and I'm not an attorney, so I'd hate to give you a legal opinion.
Yeah, because my next question has to do with that, actually. Will DOE ensure its review of these petitions conforms with the court's decision?
If I understood you correctly, could you just say the last part of that again?
Yeah, I'll do the whole question. Will DOE ensure its review of these petitions conforms with the court's decision?
Oh, sure. No, we'll do everything according to the law and our understanding of the law. There's no question about that. I will get with Bill Cooper as our general counsel at the Department of Energy, and we will ensure, whatever analysis we are required to conduct under the law, whatever we send to EPA is going to be fully compliant with not only the 10th Circuit decision, but also the federal statute.
And you may or may not be able to answer this next question, but has EPA sent you any exemption petitions from refiners who had previously submitted a petition for the exact same year but were denied a waiver the first time around?
I don't know the answer to that question, but I will find out and get right back to you.
And do you know if DOE has changed its methodology or approach for scoring small refinery exemption petitions?
No, we've not. We conduct this analysis the same way we always have, and we provide our findings to EPA for their ultimate decision on the application.
Well, if it's not changed the methodology, then doesn't it stand to reason that DOE would have no choice but to score these do-over gap year petitions exactly the same way as the department did the first time?
Yes, sir. We've not changed our methodology. I mean, we have done this in the same manner in which we've done since the creation of the program back in 2005.
Okay. And other than the 52 gap year waiver petitions, EPA reports 27 waiver petitions pending for the 2019 RFS compliance year. Has DOE completed review of those petitions and made recommendations to EPA?
I will get you an answer on that, sir. I'd have to check the status of those applications.
Okay. Yeah, well, I look forward to the answers, and I did appreciate our conversation we had prior to this hearing. I appreciate what you're doing at the DOE, and I know you've got a lot of great history with the committee, and I appreciate that. But we got to make sure that we're doing the right thing for these biofuels folks, and we have to make sure that EPA and DOE are complying with this 10th Court Circuit decision, making sure that everyone's abiding by the law, and I know you agree with that as well. So thank you very much, Mr. Secretary, and I yield back.